Good morning and welcome to Law Talks here on 4CRB. Well, today we're going to be discussing if someone has asked you to be their power of attorney should they lose capacity. It might be your mum, dad, partner or sibling, and often it feels like a simple request. After all, you might be thinking, hopefully I'll never actually need to step into the role. But if the time does come, being an attorney carries significant responsibility and many people don't realise just how much is involved. Today we're talking about what it really means to step into that role and how to be a good attorney if you've agreed to take on that responsibility. And we're joined by Attwood Marshall Lawyers partner and accredited aged care professional Debbie Sage. Good morning, Debbie.
Good morning.
So, Debbie, let's work through this. Are all attorney roles created equal? If someone has acted as an attorney before, can they assume it will be the same for the next person?
No, absolutely not, Robin. Every appointment is different. So in Queensland, an enduring power of attorney can appoint you to make financial decisions or personal health and lifestyle decisions or both. And it can also start at different times. For example, you may be appointed to make financial decisions immediately, which means the adult still has capacity, so it's at their instruction, while personal health and lifestyle decisions can only ever be made if an attorney by the attorney if the adult has lost capacity. So that's whether it's temporarily or permanently. A person's assets and personal circumstances also differ from person to person. So even if you've acted as an attorney for someone before, you should never assume that the role is going to be the same. The first step is always to read the document carefully to understand exactly what authority has been given to you, when it starts, and whether there's any limits, conditions, and preferences.
And Debbie, when an attorney is stepping in to make decisions, what should they be thinking about first?
The first thing they should be thinking about after understanding the document is what would this person want? You know, an attorney is not there to do what's easiest for them or the family or what the attorney personally thinks is best. Their role is to make decisions in a way that reflects the person's wishes, values, and best interests. They also need to ask themselves each time a decision is being made for that person, can they still make this decision themselves or at least take part in the decision-making process? Capacity can vary from one decision to another. Just because someone needs help with a really big financial decision doesn't mean they can't express their view about where they want to live or who they want involved.
Yeah. And how important is it for attorneys to keep records of the decisions they are making and what they are doing?
Oh, it's extremely important, especially for financial decisions. An attorney should keep clear records of money that's coming in and out of that adult's bank account, keep receipts wherever they can, keep bank statements, and make clear notes about major decisions that are being made. So if a house is sold, if bills are paid, if money's being spent on care, there really should be a paper trail.
Yeah.
Because good record keeping protects everyone. It protects the person whose affairs are being managed. It also protects the attorney if questions are later raised by, say, family members or other interested parties such as banks or even a tribunal. It's happening more and more often where disputes are happening in tribunals. So it's important to also be aware if an attorney is managing affairs of someone up to the date of their death, the executor of that person's estate, they actually have a duty to request an accounting from the attorney to ensure that they managed the money and the assets properly up to date of passing and have not diminished the estate inappropriately. Because unfortunately, this is just becoming way more common. You know, you think back to what an executor's duty is. Their duty is to maximise the benefit of the beneficiary.
Yes.
So if an executor is aware that an attorney has misappropriated funds, then they must look into whether or not they can retrieve those funds back or make an adjustment in the estate if the attorney is also a beneficiary and they've done the wrong thing.
And Debbie, what about conflicts of interest? Are there situations where an attorney might unintentionally cross the line?
Yeah, Unfortunately, this is happening more often than people realise, and sometimes it's not intentional. Taking a step back for listeners, a conflict of interest is when an attorney's personal interests overlap with that adult's interests. So, for example, using the adult's money for their own expenses or personal benefit, selling the adult's property to someone like a relative or a close family friend, borrowing money from them, or even just mixing their money with the attorney's own funds. Sometimes people do this with good intentions, but good intentions do not make it lawful.
Sure.
An attorney must be careful. They should not benefit personally unless the document clearly allows it or it's permitted by a tribunal, for example. The safest approach is to keep your finances separate, be as transparent as you can, and document every significant decision.
Okay. And are there things attorneys often assume they can do, but they actually fall outside the scope of being an enduring power of attorney?
Yes, it happens a lot. So people often assume an attorney can do anything once a person loses capacity, but that's not correct. An attorney can only do what the document and the law allow. So, for example, an attorney can't make or change a will for someone. They can't simply give away the person's money or assets however they think fit. There are strict limits around gifting, conflict transactions, and decisions that are highly personal in nature. So even though the authority is broad, it's not unlimited. Being an appointed an attorney is not about taking over someone's life. It's about stepping in only within the legal boundaries of that role and only when it's necessary.
So, Deb, we've previously talked about supported decision making. How does that fit into the role of an attorney, and how do you make sure the person is still involved in decisions where possible?
So, as you would probably know, supported decision making is a very important topic for me and something I'm very passionate about. Just because someone has appointed an attorney, it doesn't mean they are shut out of that decision-making process. If they can still understand information with support, if they can weigh up options and they can communicate their choice or preference, then they should be involved as much as possible.
Absolutely.
That might mean, explaining things in a simpler language, having the conversation at the best time of day that works for them, breaking down the decisions into smaller steps, or even involving trusted family members or professionals to help the adult understand. A good attorney doesn't step in too quickly. They step in only as much as is needed, and they keep the person at the centre of the decision-making process for as long as they can.
And at what point should an attorney consider getting their own legal advice? Is it only when something goes wrong, or should it be earlier?
Look, earlier is always better. In my view and in my experience, I think an attorney should always seek legal advice as soon as the document requires activation to ensure that they understand the document properly, as well as understanding what their duties and responsibilities are before they begin their role. That way, they've been properly educated on what they can and can't do in their role as attorney, which would then minimise the risk of making a decision which may put themselves at risk of personal liability or may find themselves in front of a tribunal, which might end up having them potentially stripped of their role as attorney altogether. An attorney should also consider getting legal and or financial advice before making any major decision, such as a sale of a large asset, handling large sums of money, or even moving the adult into care, because they need to understand what the correct process is and what the implications are for that adult as a result of the decision that's being made. I've had so many clients accidentally sell a property too quickly, and then the older person has lost their pension, whereas there were other options and other strategies. So if you're unsure about whether you have the appropriate authority to do something, if the document's unclear, if there's conflict around you about this, or if there's a question about the adult's capacity, seek legal advice immediately to protect yourself and the adult, because it's much easier to get guidance early than try to fix it later. A short conversation at the start can prevent serious disputes, financial mistakes, and allegations that the attorney has acted outside their powers, because that is really common now.
Yeah, Deb, being an attorney, it is an important role, but it's not about taking control, as you say. It's about acting carefully, honestly, and always in the adult's best interest. So thank you for your time this morning, Debbie.
Oh, thank you so much.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.